Okay, Bob. Okay, thank you for giving me that time to get started up here. This is cause number 534-676-401, the Rossman Estate. If I could have announcements on the record from council, please. We'll start over here. Hello there. I'm good. Are you going to be joining us? You joining us? Go ahead, counsel.
Yes, yeah, it's okay if I sit or stand.
Stand to address the court if you don't mind.
Yes. Hey, Your Honor. So my name is Jamal Hicks. I'm here on behalf of the plaintiffs, Lutra Rossman and Marcella Rossman. We also together.
Good morning, Your Honor.
morning.
Philip on behalf of plaintiffs.
Good morning.
Good morning, Your Honor. Leonard Roth.
Good morning, Mr. Roth. How are you, sir?
Good morning, Judge Billy Shepard and Joe Lizcano for Gordon Bethune, the defendant.
Good morning. And just out of absolute transparency, I worked for Continental Airlines from 1987 to 1992. A short portion of that was when Mr. Bethune was the CEO. Does anybody have an issue with me presiding over this matter? That was 30 some odd years ago. No? Okay. I wanted to make sure that everybody was clear on that, that was out there. Okay. So let's begin. This is a temporary injunction. Mr. Hicks, this is your client's motion, but I think we have a preliminary issue that you wanted to discuss, Mr. Shepard.
We do, Your Honor. We have an agreement on certain exhibits. So today the court time with me putting up people just to prove up documents.
Terrific.
So now we would offer defendants 1 through 11, and 10 includes 10A and 10B.
All right. Defendants 1 through 11 and 10 includes 10A and 10B. Is that correct? All those have been.
Yes.
Well, thank you both very much for agreeing to that. That really does get us
Yes,
to play. All right. So those are admitted. Okay. Any other housekeeping before we begin? All right. I'm ready, Mr. Hicks.
So we're here on behalf of Lutra Rossman and Marcella Rossman in regards to the deceased Jessica Rossman. Jessica Rossman was a 56-year-old woman of pretty good health. She is the daughter of Marcella Rossman, the plaintiff, and she is the sister of Lutra Rossman, the plaintiff. Jessica's a 56-year-old woman, never been married, never had any children. On or about March 30th, Jessica and the defendant traveled to Puerto Vallarta, Mexico. On or about March 31st, Ms. Rossman, who I will just say Jessica, that's okay with the court. I refer to her as Jessica. Jessica visited a dermatology clinic for a procedure. Unfortunately, inexplicably, she passed away. So on that next day, on April 1st, defendant flew back to the United States and left Jessica's deceased body in Mexico. On around that next day, April 2nd, the defendant reached out to her brother, the plaintiff, Lutra Rossman, to inform her that she passed away. And of course, after finding all those things out, Lutra Rossman and Mrs. Marcella Rossman, they had a million questions as to why, what happened. Unfortunately, at that time, the defendant didn't have those answers, so it left the plaintiff scrambling for more information. On or about April 4th, Mr. Lutra Rossman, he reached out to the United States Consulate Agency in Puerto Vallarta, Mexico, to start inquiring about what happened to his sister. Right? He was put into contact with an agent by the name of Kelly Trainer, who was a United States Consulate agent, who began to give Lucho information as Lucho explained, and he asserted that he and his mother are the next of kin, and therefore they were trying to find out what happened to their sister. Lucho also proceeded to retain his estate attorney, Mr. Leonard Roth, to begin the estate and probate proceedings, and just to get the ball rolling on Jessica as they found out, answers. So after Lucho made contact with the consulate agent, she began to give him information, and she also mentioned to him that she received information that the Forensic Institute in Jalisco, Mexico, that they had possession of Jessica's body and that they were going to perform an autopsy on her body. And also as well, the Jalisco State Prosecutor's Office was also initiating an investigation just to make sure there was no foul play or anything in regards to her death. And because of that, there was no way that they were going to release the body or allow anything to be done to the body until the autopsy was complete and the criminal investigation was complete. So in the meantime, after finding that information out, though Lucho Rossman, the brother, and Marcella Rossman, the mother, had the priority and the authority to decide on the disposal of Jessica's remains, they still were collaborating with the defendant, trying to just do what's best for all parties and trying to figure out what's going on. So initially, the defendant's idea was to have the body cremated in Mexico and the ashes come back to America. So initially, with limited information, Mrs. Marcella Rossman and Lucho Rossman, they were doing whatever they can to try to get the body back. So they asserted to the defendant that they would possibly be on board to her getting cremated in Mexico and her ashes delivered back to the United States. However, 24 hours later, Mr. Plaintiff Lucho Rossman, he got in contact with the Forensic Institute that had his sister's body, and that's when they informed him that though she died on the 31st, the Forensic Institute did not pick up her body until 28 hours later. And so that was a complete time, like a 28-hour time lapse between when she passed away and when her body was picked up. So now, plaintiff Lucho Rossman and Marcella Rossman, now they have suspicions of foul play because they want to know what happened with their daughter and sister in that 28-hour span, right? Plaintiff Lucho Rossman also had conversations with some of Jessica's childhood friends and got more information. And that's when Lucho Rossman and Marcella Rossman decided that no, they do not want their daughter cremated in Mexico. What they wanted was to get her body embalmed in Mexico and to bring her body back to the United States so they could get a second autopsy to make sure there was no foul play. And then after they received the second autopsy in America, they could proceed to getting her cremated. So after plaintiffs came to that conclusion, they reached out to their state attorney, Mr. Leonard Roth. They told them about the new findings, and they told them how they want to have the body embalmed in Mexico and returned to the United States so they could get a second autopsy to figure out what happened before any cremation. On the next day, on April 11th, Lucho Rossman, the plaintiff himself, reached out to the defendant via text message and told him about the new findings that he found out about his sister and about how there's so many suspicions of foul play and so many questions that they want to get the body embalmed in Mexico, get the body returned back to the United States for a second autopsy, and then they could possibly proceed to a cremation. So with that understanding, on or about April 12th, Mr. Lucho Rossman and his wife, they began reaching back out to Kelly Training, the United States consular agent, to begin funeral arrangements, such as figuring out how can we get the body embalmed, how can we get the body back to the United States to get a second autopsy. So they were then put into contact with local funeral homes and funeral directors in Mexico so they could begin those arrangements. So whenever the Mexican government did officially complete their autopsy and did complete their investigation and release the body, that the arrangements would be already in place to have her body embalmed and sent back to the United States. So over the next week or so, Mr. Rossman, with the authority of his mother, Marcella Rossman, they were in contact back and forth with the Forensic Institute, with the State Prosecutor's Office, and with the United States Consular Office, kind of receiving updated information. However, on or about April 24th, that is when Mr. Lucho Rossman was informed by Ms. Kelly Trainer, the United States consular agent. He was informed that his sister's death was ruled as a natural cause of death, and therefore the autopsy was complete. And because the autopsy was complete, and there was no foul play, the prosecutor's office said that since there was no foul play, that they can now release the body. However, Mr. Ross was also informed that someone had already picked up the body and claimed the body the day before on April 23rd. And at that time, the United States consulate agent couldn't identify who the person was. All she said was he was a United States citizen. She did not know who it was. She couldn't identify who it was. She could not identify where the body was, had it been cremated, disposed of, or anything. All she could confirm was that it had been picked up by a United States citizen. So after learning of that, the very next day, on April 25th, the plaintiff, Lieutenant Roston, retained counsel in order to seek a temporary restraining order to stop defendants, his agents, and everyone dealing in participation with defendant from controlling the body, possessing the body, or moving the body. Because at that time, the information that was received, they know that the body was released, but the body wasn't cremated or anything at that time. So we approached the district court, the ancillary court, in the Harris County District Court. We received a temporary restraining order in regards to that matter. However, that very next week, it was not until May 1st of 2025 when a local news reporter from the city of Houston called Lucho Rossman just to kind of talk about a story that he was reporting on in regards to the original TRO that was filed in ancillary court. It was at that time that Mr. Lucho Rossman was informed by this reporter that his sister was already cremated on April 23rd and that her ashes were already delivered to defendant on April 25th. So while the mother and the son were scrambling trying to find answers on where their sister is, where their daughter is, where her remains are, as they have the right to decide how to dispose of her, that entire time, defendant had already sent a representative to claim the body, get the body cremated, and the ashes sent back to Houston. So as the action committed and as defendants filed their response and we got more information, it wasn't until then that the plaintiffs learned that defendant sent a representative by the name of Roel to Mexico on April 15th to try to get possession of the body. And during that time, Mr. Roel, he submitted paperwork and documentation asserting to the Mexican government officials that Jessica Rossman was his wife and his domestic partner, and therefore he had the authority to take possession of her body and get it cremated, and that he was sending a representative out there on his behalf, Mr. Roel, to take possession of that body and to get it cremated. The Mexican government officials accepted those assertions as true. They had Mr. Roel sign statements saying that defendant was a domestic partner and husband of Jessica Rossman, and therefore he had the authority. And so the Mexican officials took that word, they released the body to the defendant's representative, Roel Guerra. They released the body to him, and on that same day, he went ahead and got the body cremated. And then on April 25th, he flew back home to Houston and delivered those ashes to the defendant. And not one time during that entire time did anyone communicate that to the rightful parties that had the power to make those decisions. Not one time the defendant tell the plaintiff, the mother, or the brother that they were going to get the body cremated, that they took possession of it, that they were going to assert that they were married and take possession of it, and that the ashes were just going to be delivered to him. Not one time did they ever communicate with that, and not one time did the plaintiffs ever give the defendant the authority to do so. And because of that, Your Honor, that's what led us here today. Because the defendant has no right, no authority to not only did he get the body cremated and get the ashes delivered back home to himself, he did not receive authority not by the family nor any Texas laws, as Jessica Rossman has never been married. She has never had any children. And in fact, respectfully, and I say that with all due respect, the defendant was married up until 2024 when his wife deceased. So at no time did Jessica Rossman ever have any husband or anything. And so we're here today seeking a temporary injunction for that reason. And so we filed this action with the cause of action against the defendant being that one, negligent mishandling of the corpse. Because the defendant went against the family's wishes, he got the body cremated. He took possession of the body. He sent a representative out there, didn't get any type of authority from any of his plaintiffs. He sent a representative out there, got the body cremated, and got the ashes delivered back to his home with no authority and against the family's wishes. Also, our second cause of action is negligence per se, as the defendant clearly and verbatimly violated section 711 of the Texas Health and Safety Code. And the Texas Health and Safety Code states that unless the decedent has left directions in writing for the disposition of the decedent's remains, the following persons in the priority listed have the right to control the disposition, including cremation of the decedent's remains, and shall inter the remains and are allowed at reasonable cost of interment. That priority list, number one, the person designated in the written instrument signed by the decedent. Jessica Rossman does not have any written instrument where she gave anyone the authority to dispose of her remains. So she does not have any written instrument. Number two, the decedent's surviving spouse. Jessica Rossman was never married, so she's never had a spouse. That leads us down to prong three. Any one of the decedent's surviving adult children. Jessica Rossman never had any children. So next in the priority line is either one of the decedent's surviving parents. Mrs. Marcella Rossman, who's alive and well and is before you today, is Jessica Rossman's surviving parent. Next in line on the priority list is any one of the decedent's surviving adult siblings. Lucha Rossman is alive and well in front of you today. Therefore, defendant is in complete violation of section 711 of the Texas Health and Safety Code, as Marcella Rossman, the mother, and Lucha Rossman had the right to control. They had the right and still have the right to control the disposition of Jessica's remains, as they are the next of kin, and they fall verbatim in line on this priority list stated by section 711 of the Texas Health and Safety Code. Therefore, we filed this action against the defendant, and we know that, and it's of our belief that we have probable right to relief of our causes of action because of the foregoing of what I stated, because Mr. Bethune, the defendant, never had any authority from the family to do any of the things that he did. He still does not have authority to have possession of the remains, and he still currently has the remains in his possession. The injury is imminent because currently, as we sit before you, Judge, he has the remains of an individual that he has no right to, that he's never been married to, doesn't have any children with, that he has no right to, and the rightful parties that have the right to control the disposal and the disposition of the remains before you today, and they do not have possession, and they cannot control what they do with the action. Furthermore, Your Honor, the injury is irreparable for a couple of reasons. One, as governed by the Texas Supreme Court, the next of kin to a deceased person has what's called a quasi-property right to control the burial and the disposition of their family members. So that right has been stripped away and is currently being stripped away from them. Also, the injury is irreparable because the body has been cremated, therefore preventing a second autopsy, which the whole point of the second autopsy was just to make sure there wasn't any foul play and to make sure there wasn't any suspicion, right? And now that has been stripped away from the defendants. However, they would like not only to have the ashes of their daughter and sister just because they have the right to dispose of them how they want, but they also would like to get a forensic toxicology report on the ashes as well to try to figure out if there was any more further type of foul play, if she had any drugs in her system or anything. As we sit here today, the only thing we have is a Mexican autopsy saying she, a 56-year-old woman who went to a dermatology clinic, died of natural causes. So the injury is imminent and it's irreparable. And therefore, we sit here today seeking a temporary injunction. And for that temporary injunction, we're seeking an injunction to enjoin the defendants, its agents, its assistants, anyone in participation with the defendant from possessing, controlling the disposition of Jessica's remains We want to enjoin defendant from destroying Jessica's remains, from altering any vessels or containers or urns that Jessica's remains may be in. We want to enjoin the defendant from interfering with plaintiff's ability to take possession of Jessica's remains. We want to enjoin them from not disclosing to the plaintiffs the whereabouts and physical location of Jessica's remains. And we want to enjoin them from turning over possession of Jessica's remains to the plaintiffs without keeping her remains inside the vessel or container or urn that currently hold Jessica's remains. So that is why we're here before you today.
Thank you, sir. Comments?
Yes, Your Honor, may I approach the bench?
You may. Thank you.
They'll provide to this case also. And. Your Honor, this is the middle of the exhibit.
Oh, thank you very much.
Be sure I provide 111 already.
They are admitted, yes. Mhm.
I'm going to take the court on its awkward to allow me to walk through my lengthy response to the other file until Friday afternoon. And for that, I apologize that I was not sort of just walking until Thursday night.
I realize I gave a very short time for the hearing. I understand. Okay, thank you.
By way of background, and I'm going to use first names because we have lots of laws in the secret.
Understood.
Lucio and Marcelo became estranged from Jessica sometime before 2015, more than 10 years before her death. So much so that in Jessica's will, she expressly disinherited both Lucio and Marcelo. And she didn't just not leave them anything. She said, I expressly disinherit my parents, Marcelo and Charles Rossman, and my brother, Lucio Rossman. I think the evidence will show that as of the time of Jessica's death, Lucio and Marcelo had not seen or spoken to Jessica for more than a decade. As Mr. Hicks said, Mr. Bethune and Jessica traveled to Puerto Vallarta on March 30th for a planned 2-night stay. Jessica had a condominium there. Mr. Bethune and Jessica had been domestic partners and living together for most of the prior 15 years to the time they left. Jessica did pass during a cosmetic procedure on March 31st. Mr. Bethune is 83 years old and suffers from Parkinson's disease. The next day, April 1st, he still did not have access to the line. He doesn't speak Spanish. He didn't know anyone in Puerto Vallarta. He was in shock, and he couldn't make anything happen, couldn't assist. So for that reason, late in the day on April 1st, he flew back to Houston, where he thought he could help because he has assistance and can at least speak the language. After returning to Houston, evidence will show that Mr. Bethune hired Mexican lawyers and did everything that he was supposed to do in accordance with Mexican law. What we know, based on what Mr. Hicks said and the evidence, is that Lucio learned of Jessica's death not later than April 4th, perhaps before, but not later than April 4th. On April 9th, Lucio sent a text message to Mr. Bethune that read as follows. Our goals are very much in line. My thought, which I think is yours, is to have Jess cremated in Mexico and then brought back home. Then we would have her remains sent directly to you. That is the 3, and that is exactly what happened in this case in accordance with Lucio's stated goal. Also on April 9th, Lucio sent a text message to Mr. Bethune that said, I will do whatever I can and as quickly as I can on my end to get this process going and get Jess back to use. On April 10th, the very next day, any purported right that Lucio and Marcella had under Health and Safety Code section 711.002 to control the disposition of Jessica's body expired. And while Mr. Hicks,
Do you have any case law on that?
I have the statute.
I have the statute too. I've read it and I've applied it many times in this court, but I've not heard that cremation ends a person's right to final disposition. Do you have anything that clarifies that?
Wait, the question is,
Maybe I misunderstood your argument. This will be your opportunity to clarify.
Okay.
And my the typical way that I talk with attorneys is I engage in conversation when I'm maybe a little bit confused, but I thought I read in your response, and I think I'm hearing in your argument that cremation terminates somebody's right to control the disposition of remains.
that is not wrong.
I'm sorry, I misunderstood you. Would you please clarify?
Under section 711.002A1, the statute says that any identified person in section A, right, if any, to control the disposition of a body or remain terminates on the earlier of, and I'll just read it so there's no dispute, the 6th day after the date the person received notice of the death, or the 10th day after the death.
I see, I understand.
So I'm not saying cremation, I'm saying a law termination.
I understand. Okay, I misunderstood your argument. Thank you for clarifying.
Sure. The very next day, on April 11th, Lucio sent a text to Mr. Bethune that said he quote unquote may, not did, but may, want Jessica's body brought home so a second autopsy could be performed. However, neither Lucio nor Marcella brought Jessica's body home or arranged for a second autopsy to be performed. The following day, April 12th, while Jessica lay in a Mexican morgue, Lucio went on a vacation to Paris, France. I don't know when he returned. We're going to find that out today. But instead of making arrangements for his sister, he went on a vacation to Paris. On April 15th, Roel Herrera, Jessica's oldest friend and a Spanish speaker, traveled to Puerto Vallarta and through Mexican borders, and with the authorization of the Mexican government, Jessica's body was cremated on April 23rd, more than 3 weeks after she died, in Puerto Vallarta, in accordance with Mexican law and Mexican authorities' authorization, and specifically in Exhibit 10A. And Your Honor, 10A is a certified translation to English of 10B. In 10A, you will see that the United Mexican States Civil Registry entered a quote-unquote cremation order stating that the cremation is authorized. The United Mexican States issued a death certificate stating that the manner of disposition would be cremation, and that, and this is a quote, the body will be cremated with the authorization of the agent of the public ministry. This was all done in accordance with Mexican law. Texas law, and I'll get into this in legal arguments, doesn't apply in Puerto Vallarta, Jalisco, Mexico. The local law applies there, and this was all done through Mexican lawyers and the Mexican government and their authority. On April 24th, an application to probate Jessica's will was filed, and the full will for the first time became public record. For the first time, the will that expressly disinherits Lucio and Marcella became available to both of them in the world, and the next day, Lucio filed this lawsuit. That's where we stand today. Your Honor, I handed the court a notebook of argument aims, and starting keeping this up to demonstrative two. As the court knows, an injunction, the purpose of an injunction is to maintain the status quo. And the three of them, the plaintiff has to have a cause of action. The plaintiff has to prove.
All right, excuse me, little IT help here. So if you have it plugged into the HDMI cable on your, okay, you can, there's your controller right there, and you can hit publish, and publish will send it to all the monitors, including the remote participant. Cable one, publish, there you go.
Thank you.
Very good.
As the court knows, the purpose of an injunction is to maintain the status quo, and there are three elements. First, the plaintiff has to have a cause of action against the defendant. Secondly, the plaintiff has to have a probable right of recovery. And thirdly, the plaintiff must have an imminent and irreparable injury. Importantly here, it is the plaintiff's burden of proof to prove each of these elements. And as I go through the argument, Judge, I will contend and argue that the plaintiffs have failed on each of these elements and more that they need to get an injunction. And if we can look at demonstrative 3, injunctive relief is extraordinary, equitable relief, and as a result, it has to be based on verification by affidavit. As the court knows, affidavits and verifications must be based on personal knowledge. An affidavit or verification that is not based on personal knowledge is, as a matter of law, legally insufficient and ineffective. The verifications attached to Lucho's and Marcella's petition here is not based on personal knowledge, nor could it be, because they don't know what happened in Mexico and in Texas when Lucho was in East Hampton, New York, and Paris, France, and when Marcella was in East Hampton, New York. Well, because of that, they say in the verifications, the facts contained in the petition are true and correct and based on quote-unquote first-hand knowledge. Well, I don't know what first-hand knowledge is. It's not a legal term, but it's not personal. And for that reason, they are not entitled to an injunction. If the court will turn to tab 4, as I stated, the purpose of an injunction was to maintain the status quo before there was a dispute. Here, at all times, Mr. Bethune had control of Jessica's body and then Jessica's ashes. And that was all before this lawsuit was filed. So the status quo is the way it actually is right now. And that is Mr. Bethune has Jessica's ashes. He has respectfully maintained them in the exact form that he received them. He has maintained that even though he never served with the TRO that the district court entered, he was serving with the petition, but not the TRO. And he has maintained them ever, even though the district court's TRO has expired. And he will continue to maintain that show in the exact form that he received them. Until this case is over, until your honor tells us something else to do, or Court of Appeals, if that's the route it goes, or until there is some agreement with Lucho. But the injunction that Lucho and Marcella are asking for here would actually destroy the status quo, not maintain it. So they're not entitled to it. Under tab demonstrative 5, Your Honor, it simply discusses the legal citations that chapter or section 711.002 of the Health and Safety Code does not apply extraterritorially in Mexico. As recently as 10 days ago, on May 9th, the Supreme Court of Texas once again, in the case of Cole v. Cheatham, normally I'm not quick on these cases, that was my case though, so I haven't heard about this one. In Cole v. Cheatham, the legislature has to express a clear intent for a statute to apply extraterritorially in another state. or another country. And if there is no clear intent, there is no extraterritorial application. Well, here, as I've stated here, and I'm not going to read it to the court, but the statute is clear that it applies only in Texas. It talks about the Texas Historical Commission, counties in Texas, this state, Texas state law. The statute simply does not apply. Yet another reason Lucho and Marcella are not entitled to an injunction. Under tab 6, Your Honor, assuming even that, well, Lucho and Marcella lack standing. And the reason they lack standing is because they allege that their claims derived from the statute doesn't apply, therefore they lack standing, yet another reason they are not entitled to an injunction.
Well, if the cremains are here in Texas, is that, I mean, explain your standing issue. I've got a different thought in mind about something else, but go ahead.
Yeah, as they pleaded the case, they say, if you look at their petition, they quote section 711.002. Then they say, based on the foregoing, we have the right to seek relief. And they cite case law, and then they say it is superseded by 711.002. If 711.002 does not apply, then based on their pleadings, they lack standing. But it doesn't apply for more than one reason. It doesn't apply because of extraterritoriality. Got that worked out. But it also doesn't apply. Now, I get it, the actors are in Texas. It doesn't apply because they forfeited their right on April 10th to handle the disposition of the body. The statute, it's section A1, right under the statute that they quoted in full in their pleadings and talked to you about, says that. If you'll go to demonstrative 7, and that is just the argument that I've touched on already, and that is quoted here specifically what 711.002A1 says. And I'll just quote, on the 10th day after death, the person's right to control the disposition is permanent. Their right, to the extent they had it, terminated on April 10th. Jessica was not cremated until almost 2 weeks later on April 23rd. Lucho and Marcella, even after the 10th, did not make arrangements for the disposition of Jessica's body. They did not travel to Mexico. They did not even travel to Houston. To our knowledge, they did not hire a Mexican lawyer to make sure things were legal in Mexico like Mr. Bethune did. So for that reason, their right, to the extent that they had it, was terminated. Your Honor, under demonstrative 8, this relates to causation of damages, and it simply outlines, and you'll hear from the evidence, the nature of the estrangement, how long it was, how long there was no contact, and because of that, it is improbable, not probable, that they could prove that Mr. Bethune caused any accident to them. Yet another reason that they are not entitled to an injunction. Demonstrative 9, we've asserted a number of equitable defenses. They're all based on the same general facts that are bullet pointed in demonstrative 9, but it is essentially based on the estrangement, the disinheritance, the not making arrangements to dispose of Jessica's body, to take a vacation for Paris, France instead, not hire a Mexican lawyer, to not do anything with the authorization of the Mexican government like Mr. Bethune did. So likely. And lastly, under demonstrative 10, Your Honor, is relates to whether there is an imminent and irreparable injury, which they must also prove. An irreparable injury is one that cannot adequately be compensated in damages, or for which damages cannot be measured. by any certain pecuniary standard? Well, we know there is no imminent harm because Mr. Bethune has maintained Jessica's ashes intact and respectfully in every procedure since the moment of them, even though it was never TRO expired. And as I said, he will continue to do so until we get an agreement with Blue Cherries. And we know the damages they seek are not irreparable because notwithstanding their estrangement for a decade or more, and they're not seeing or speaking with their sister and daughter respectively for that amount of time, notwithstanding their failure to arrange for the disposition of the body, including allowing their alleged statutory right, if they have one, to expire. They want $10 million in mental anguish damages from Mr. Bethune. And so they have conceded in their pleadings that the damages they seek are not irreparable. And lastly, Your Honor, the evidence is going to show, and it relates to a lot of our offenses, that Mr. Bethune has unconditionally offered to divide the ashes equally between Mr. Bethune on the one hand and Lucho and Marcelo on the other. And he said, you can still sue me for $10 million. They rejected that. Mr. Bethune has offered to inter the remains in a wall niche at a mutually agreeable cemetery in Houston and said, but if we do that, you can still sue me for $10 million. They rejected that. Mr. Bethune has offered to shred Jessica's ashes in a mutually agreeable place that she loved in Houston. Herman Park would be one example. And she said, if you agree to that, you can still sue me for $10 million. That too was rejected. This case, Your Honor, is not about Jessica's ashes. It's about money. It's about $10 million they're asking for Mr. Bethune. It's about them filing a suit 24 hours after Jessica's will expressly disinheriting them became public record. And I think from the 4 years of evidence, and my exhibits alone support all I've said, but the testimony will even further. Thank you.
Thank you. I want to concentrate on the issues as a matter of law before we get into fact issues and evidence and all that good stuff. Mr. Hicks, could you address the issue of standing, the issue of personal knowledge, because frankly, that's why your TRO was denied and many other reasons, and irreparable injury. Could you address those for me?
Yes, Your Honor.
Mm-hmm.
First and foremost, when it comes to lack of standing argument, pursuant to Rule 93 of the Texas Rule of Civil Procedures, it says that the pleading setting of any of the following matters, unless the truth of such matter appear of record, shall be verified by affidavit. One, that the plaintiff has not legal capacity.
I'm sorry, maybe I need to clarify. What Mr. Shepard was talking about was the lapse in the statute under 711A-1. And the fact that
that the allegation that his rights were terminated.
There you go.
Okay, yes, I can speak to that. Your Honor.
Okay, thank you.
Yes, Your Honor. So, okay, first and foremost, 3 things in regards to that. One, well, I'll address. You said law. I'll just go straight to the statute.
Thank you.
I'll address the statute.
Okay.
So, as the evidence will show, and as I said in my opening, that Mr. Rossman and Mrs. Marcella Rossman, they were in contact with Kelly Trainer, the United States Consulate agent, trying to find arrangements, right? Trying to find arrangements because they knew that first and foremost, no one can do anything with the body, right? Because the Forensic Institute was still doing the autopsy and the local prosecutor's office was still doing the investigation. So they notified everyone that there's no way that anyone could take the possession of the body or do anything with the body until the investigation was complete. And though she died on March 31st, that investigation was not complete until April 23rd. So no one could do anything with the body anyway. However, Mr. Rossman and Mrs. Marcella Rossman were already in contact with local funeral home directors trying to figure out how to get her body embalmed. Also, Your Honor, if I take it a step further, however, if the court does accept the defendant's argument as true, first and foremost, according to Section 711, Mrs. Marcella Rossman had the first right of priority. Right? However, if the court does accept the defendant's argument that the rights were terminated because there were no arrangements made within 10 days, even though there was nothing no one could do with the body because it was on hold, that technically, if the court follows Section 711, that means that Marcella Rossman's right was terminated. And according to Section 11, it says that if that person's right to control the disposition is terminated, that right to control the disposition is passed to the following persons in the following priority. Any other person in the same priority class, which Lucho is not in the same priority class as Marcella Rossman because he's not a parent. However, the second prong says that a person in a different priority class. Therefore, the right to control the disposition, if the court accepts the argument that Marcella Rossman's right to terminate, even though the defense is saying Lucho's right was terminated. However, technically, if Marcella Rossman's right was terminated, it was automatically passed down who's next to the priority list, which that would be Lucho Rossman. And once it's passed down.
Stop right there. Mr. Shepherd, I'd like you to respond to that.
I'm sorry about.
So we're talking about the right to control the disposition of remains and the 6th to 10th day requirement. After that expires, what's the next part of that statute?
The right to control the disposition is passed to the following persons in the following priority. Right. And then specify the person.
Right.
What I don't think that means is persons who have already forfeited their right.
Okay. If the number one person with number one priority forfeits their right, does everybody below that priority list also forfeit their right?
If they haven't.
Everybody else forfeits their right after that. I don't think that's what that statute says. Would you reread that and tell me if you think that's what that means?
Sure. Section A-1-2.
It is section A-1 and then number 1 and number 2.
Okay, the person's right to control the disposition is terminated, and the right to control the disposition is passed to the following persons in the following priority. Any other person, in the same priority class under subsection A, as a person whose right was terminated, or a person in a different priority class in the priority listed in subsection A.
Right, so it goes down to the next person, right?
And
that's a plain reading of the statute. I'm making Mr. Hicks's argument to you to hear your response.
But the latest that anything can happen is 10 days after the death.
All right.
So,
all right. So according to the statute, it says the person with priority has to do something within 10 days. And if they fail, then it goes down to the next person. Is that not what it says?
I don't think that it says it goes down to the next person and.
Tell me what your understanding of that statute is.
And there's no limit. My understanding is somebody who cares about the deceased needs to do something within 10 days.
I don't disagree with you there. We're just parsing the statute at this point. And see, we're going to get to other parts of the temporary injunction matter in just a minute, but I'll tell you the way that I've seen this applied is that when the person with priority fails to do something, the next person in line typically can come in and do something. That's what this is. This is savings clause. It's a safe harbor. Do you disagree with that? Or do you say everybody with any priority has to do it within 10 days?
I think everybody with any priority has to do it within 10 days. However,
Okay.
even assuming the law is what the court says it is.
Well, that's how it's been applied for millennia. It's how it's been applied in my court. And I'll tell you, here are the situations where it arises. We have parents of a deceased person who are divorced or missing or not involved. They don't do anything. And then the brother comes in after the 10th day and says, I tried to get mom and dad to do something. Now it's my turn. And typically we've been doing, and that's kind of what this statute does, is it says the person in first priority, you have priority, you have first right of refusal basically for 10 days. If you don't take up that option, then the next person in line has the ability to do this. And I think that's what this statute is saying, but it doesn't say that the first person who forfeits their right also forfeits their right as to every, or also forfeits the right as to every other person in the same class, or in a subsequent class rather.
I would read the statute a little bit differently in that.
Okay.
But I'm going to get back to it.
But is that how you would like the court to interpret the statute? Because if that's how the court is going to interpret the statute, then everybody loses their right to control the disposition of remains after the expiration of 10 days if the first person with priority forfeits.
That would be correct, but let me.
That would turn the statute on its head, I think, wouldn't it?
Assuming the statute is construed, and I know it has been.
Let's do argument. Okay.
As a practical matter, this court and other probate courts have construed it. Would show then his right terminated if he has another 10 days. His right terminated.
Yeah, the wacky thing is it really doesn't say anything about that, but go ahead.
It doesn't.
No, it's
doesn't.
not clear, is it?
But I don't think that if the first person forfeits their right, the right's terminated, the second person has in perpetuity. While the body lives in a morgue in a foreign country. Yeah. And while the person is taking vacation in Paris, France, to do this.
And of course, we're not even getting to the extraterritorial matter. Thank you. I was going to say terrestrial, but I know that's not true. So it doesn't apply there. We haven't even hit that argument yet. My question is going to lead to this, which is where I started. The remains are here. And who has the right to control those remains at this particular point? And your argument is everybody's right has terminated because 10 days have passed. If everybody's right is terminated, then who has the right?
It's not listed in the statute.
I agree. It's not listed in the statute. So then how do we resolve that?
I think we resolve it through equity.
We do. We resolve it through equity. I think Mr. Hicks brought up another thing of quasi-property, which is kind of a weird substance. Now, in 3 weeks, I'm going to have an article on something like that on my Substack because it's burial rights and the rights to control the disposition of remains are cloudy. And I thought I would do some deep diving research on this, and so I have, and I'll be publishing that in about 3 weeks. But that's not where we are here today. I'm only saying that to say that this is a topic that interests me greatly, and I don't have the answer, and I'm looking for the answer. And I think you and I agree that after 10 days, does the next person in line either have a right in perpetuity, or is the statute silent? Does everybody have to jump in within those 10 days, regardless of your priority?
I think if the next person in line, if it goes to the next person in line, they have to act with diligence. The statute says 10 days is a diligent period. Yeah. That didn't happen.
No, I agree. That didn't quite happen here. Right. But I'm sorry, but I didn't mean to take you down that rabbit hole, but that is an interesting aspect of this unclear statute that is a bit of an enigma. And I appreciate your input. Thank you. All right. I'm sorry. I didn't mean to interrupt your argument.
Oh, well, yeah, I was completing my argument, Your Honor. That's what I was asserting that if the court does consider the argument that Marcella Rossman's right terminated, even though defense clearly argues that Lucho's right terminated. If the court agrees that Marcellus Rossman's right terminated, then it automatically files down on Lucho. And there is nothing else in the statute that says, oh, when it falls down to the next person in line, that there's a 10-day requirement or anything. The statute is silent to that. So there's no timeline that said that, oh, now that it's passed down on Lucho, he has 10 days to do it.
Probably needs to be clarified by the statute or the legislature, doesn't it?
Yeah, thank you. And respectfully, it still does not say that a partner or someone else now can take possession and control the disposition of the body as well.
Well, I think we're going to get to that in a little bit, but I think that the evidence that's been presented and offered and accepted is that the procedures under Mexican law were followed, and I don't have any jurisdiction over Mexican law. So whatever happened in Mexico under Mexican law is not a concern of this court, as far as I can see, unless you have a different angle that I'm not aware of. Let's get to personal knowledge. I really struggled with how your client has personal knowledge of any of this.
With personal knowledge of any of the
Reading newspaper articles or hearing it from somebody else or making speculative conclusory statements did not indicate to me that your client has personal knowledge of any of this other than his direct conversation with Mr. Bethune via text, in which he appears to have agreed to a cremation.
Oh, well, respect the honor. I would also consider that the second text message as well, when he informed him about the new information.
That wasn't my point. My point was that seems to be, no, you don't have to apologize, of course, ever. You always make your argument strongly and clearly, and don't worry about apologies. The point that I was trying to make is that appears to me the only direct evidence of some personal knowledge. There was no other evidence of direct personal knowledge. It was not implied, but it was stated clearly that some of the knowledge came from other sources, not his own direct knowledge.
Correct. Well, yeah, and I mean, these are conversations that he had directly with, such as he had.
Right, but you see, your affidavit, if you attached one, should have had facts that were not conclusory. They should have had facts that showed the direct personal knowledge. But what your client did in the pleading is make conclusory statement that did not provide any evidence of whom he spoke with. You know, it was just simply I spoke with somebody. This is what they said. That's
Gotcha. Instead of stating who specifically.
how the conversation came about, because I should be able to see from the pleading or the affidavit, which probably would have been better in this case, direct evidence that he came into some personal knowledge about this. But what I read really were conclusory statements.
Right, yeah. And we do have Mr. Rossman here to give testimony as well for the conversation that he had and the information that him and his mother.
I foresee a flurry of objections when that happens. Yes, sir.
It's the pleading before the hearing starts.
No, I know.
It has to be verified by personal knowledge.
You're exactly, that's what we're talking about right now. I think we just did an aside here, but that's exactly what we're talking about. Mr. Rossman, are you able to hear us?
Yes, sir.
Oh, I'm sorry, hang on just a quick second here. Could you state that again? Are you able to hear us?
Yes, Your Honor, I can hear.
Okay, I thought so. Okay, I got a message that somebody called and said you were unable to hear. Okay, you're good. All right.
Yes, sir.
All right, yes, you may continue.
Yes, Your Honor. So all the information that's in the petition, yes, Your Honor, that is from conversations that Lucho Rossman personally had with individuals such as the defendant, such as from the United States Consulate agent, and such as the Forensic Institute.
Okay, can you point to the pleading where this is a direct indication to the court of knowledge and not some inference of learning this through others.
Yes, sir. Looks.
And I've got it right here, so I can walk through it with you.
Yes.
It's probably just the Article 4, Section 4, whatever you want to call that. I think that's all that there is.
Well, so finding out about her death and finding out that she went to a dermatology clinic and that she passed away, and that the defendant was back home, was based off of a phone conversation from plaintiff Luchar Osman and the defendant. So that's how he was made aware of the death and how she was back home. I'm trying to go up order here.
Yeah, it's all right. Hey, take your time. I got plenty.
When it comes to learning about that the defendant had, when it comes to learning about the defendant improperly had Jessica's body cremated and that the ashes were defended, that comes from a first-hand conversation from.
But she makes a conclusory statement that it was improper.
Well, that Jessica's body was cremated.
Okay. I think everybody agrees that her body was cremated.
Yeah, well, yes, I was speaking to the fact of, I was trying to say how he had personal knowledge, basically who he received that knowledge from.
All right.
And that is from a Houston Chronicle reporter who had already talked to defense's counsel.
Third hand.
Right. That is how
Through a reporter who talked to somebody else. That's personal knowledge?
I could see that, Your Honor. See that.
Do you see my issue, my problem here?
Yes, Your Honor. Yes, Your Honor.
All right. Well, I'll tell you what, why don't we move on to the next topic of irreparable damages? Can you explain that? And this has to do with the cremains, not.
Yeah, just the cremains.
Okay.
Yeah.
What's the irreparable damage?
So the irreparable damage is one that that the defendants have possibly lost causes of action or finding any type of way of what really happened to their sister and daughter in Mexico, and there is nobody left to do any type of autopsy. The only thing that could be done.
Well, that's already done, so.
Yeah, and the only thing that can be done now is a forensic toxicology report from her cremains.
Okay.
Yes, so that is the only thing that still could be done, and that they don't have the right to pursue that. Well, they have the right to pursue it, but they don't have the ability to do so because they don't have possession of the ashes. And if the ashes are destroyed.
Wait a minute, they don't have possession of the, who's they?
They meaning the plaintiffs. The plaintiffs
Your
would not have.
clients. Okay, sorry, when you say they,
I
I'm thinking
apologize.
somebody else.
Yeah, they meaning
Okay,
the brother.
Your
and
clients.
my clients.
okay.
They currently do not have possession. And therefore, as every day that goes by, they still don't have any answers to any questions of what happened to their sister and their daughter. And they want to pursue more. They want to figure out what exactly happened in Mexico. And so they need those actions to try to answer some questions that they have. And so not only is it irreparable because they can't perform an autopsy, but also they currently now cannot do any type of toxicology reports, any type of testing on her remains just to try to get one final answer of what happened to their sister.
Okay, so what kind of status quo are you trying to preserve at this point with your injunction?
Well, the status quo, so we're trying to make sure, one, that the ashes that the control and the disposition of the remains in the hands of the rightful parties.
Okay, but you're asking for actually ultimate relief there, not status quo, right?
Yeah, well, yeah, because we want to stop the defendants from not only having possession, but from.
Well, that sounds like a lawsuit, but as far as the injunction is concerned, what status quo are you seeking?
What we are seeking to preserve them, and also too, so they can get them tested as well. For any questions of foul play, any suspicions of foul play, any drugs, or anything that may be in her remains as well. And so that is the status quo, to make sure that the ashes and the remains are in the rightful possession of the owner, and that
Well,
they
I
have
can't
the
make the
ability to run
determination,
tests.
sorry, I can't make the determination of rightful owner, if we're gonna use that term, until a full trial, right?
Correct.
Okay, so I can't offer an advisory opinion on that at this juncture. What I can do, if all else is appropriately done, is maintain how things are until the outcome, right? Isn't that the purpose of an injunction? I mean, there is positive injunctive relief to get somebody to do something, but that's sometimes, that's not what we're here to do today. And that's kind of not what was, anyway, I'm not going to go into that.
Yes.
All right, so I'm trying to just understand that. And it sounds to me, well, I heard anyway from your friends on the other side, that they would agree to inter the remains in a columbarium or a wall cemetery, but put it right in there. And it seems to me that if anybody with authority to inspect those for whatever reason would be able to get them from there. Have you talked, and I know that they've talked to you about that. Have you considered that?
Have I considered
And have you considered it? You don't have to tell me whether you would agree. That would be improper for me to ask you, but have you considered that and talked to your clients about that?
about which part? We have talked about it being
Keeping
in a
them
neutral place.
intact interred in a wall niche, I think is the word that I heard.
Yes, we have discussed that.
And okay, but that's not what you're asking for me to do today.
No, Your Honor.
You're asking for me to do what?
So we're asking you to refrain I don't want to call him a stranger, but refrain a non-next of kin from disposing of the ashes, from altering the ashes, and possessing the ashes, and controlling, because right now he has control of the disposition. He has it in his possession, so he can do anything, and so we want to enjoin him from doing anything with those ashes.
Okay, and let's see, you're set tomorrow to have the will probated, isn't that right? Is it tomorrow?
I'm not the state attorney.
Mr. Roth? Isn't it set for tomorrow to have the will admitted to probate? I'm sorry, tomorrow, are you set to have a hearing on the probate of Ms. Rossman's will? Isn't that tomorrow? Oh, I'm sorry, I thought you were. Okay, it's on the schedule for tomorrow. But Mr. Avant, yes, from Gray Reed. All right, so I'm sorry, Mr. Roth, you're typically the guy who probates wills, and so I wanted to, now I know where everybody is on all of this. So you brought up the quasi-property theory, and under a quasi-property theory, would you agree or disagree that the will would control?
Oh, I do agree that the will controls, Your Honor.
All right, and who inherits under the will?
Who inherits the benefits of the will? The benefits.
Who are the distributees of the will?
Oh, I don't think the will is in here, but that she has beneficiaries that has benefits of the will.
Okay, well, let me be more clear. To whom does she give her property in the will? And let's even be more clear than that. Are your clients any of the distributees under the will?
No, Your Honor, but.
No. Okay, that's what I read in the will too.
And can I add more?
Oh, of course. I don't mean to interrupt you, certainly.
Yeah. So, yes, the will does state that Lucha Rossman and Marcella Rossman are disinherited, and she wishes that none of those named individuals, including the plaintiffs, receive any benefit from her will.
Okay.
However, not one time did anything in the will did she talk about how she wants her body disposed of, or did she give the right or write down to anyone, hey, this.
No, that would have been a 7-Eleven issue, and sometimes you can put those in a will. I think it's bad practice to do it that way, but sometimes you could put it in the will, but
So
what we're talking about here is quasi-property now, right?
correct.
You brought that up, so you understand the theory of quasi-property with respect to a decedent, right?
Correct.
Okay. So at that point, who would have a right to determine where those cremains are?
At that point.
Yeah.
At that point that they have the quasi-property right. Well, it would be the next of kin.
No, that's not in the will anywhere.
Well, yeah, well, in the will, there's nothing that speaks to anything about disposing of her body. It's just talking about the benefits in which she shelled out money.
Okay, I think we're probably crossing each other here. Mr. Shepherd, do you understand my question?
I do.
Would you like to chime in?
The primary D by Z under the will is Roel Bear, who was here in this courtroom today.
Mm-hmm. And wasn't it Roel who was down in Mexico doing this?
That is correct.
Okay.
Her oldest and longest.
Mm-hmm. Do you understand what I'm saying now?
Apologies, Your Honor. Because obviously I keep going back to the same answer, so obviously I'm not really understanding what your question is. I guess because this is my thought process, Your Honor. My thought process is that the will only speaks to, she disinherited the plaintiffs, but only from receiving the benefits of the will. She did not designate anyone, nor did she de-designate the plaintiffs from making decisions in regards to the disposition of her body. And because there's nothing in her will, then we have to follow Texas law. And yeah, so it's not stated in her will of how she wants her body to be disposed of.
Oh, that's true. That would have been something that we would cover under 7-Eleven prior to the probate of the will, because it even says so prior to the probate of the will.
Correct, yeah.
Right. But the will apparently is going to be probated tomorrow, and I don't know what the outcome will be. I haven't reviewed it, haven't looked at it, but let's assume, just for our argument's sake, that the will is admitted to probate. Do your clients have any right to any of Ms. Rossman's property, including quasi-property?
Property.
You might want to ask Mr.
Yeah,
Ross.
that's what I was going to
You might want to confer with Mr. Ross.
Yeah.
Yeah, I know.
Your instinct when you came in to say, I'm not sure I take jurisdiction of things, that's absolutely correct. Because there's no claim that can be made against the state. No one's an interested party of this state, and no one's a beneficiary of this state.
Oh, can you clarify your role in this for me? Are you representing Lucho?
I'm representing the Boston family.
Ah.
Lucho and Spawn is fine. They were formerly residents of Houston.
Oh, okay.
And,
All right.
And representing their mother as well.
All right. So you're here on their behalf as well, not on Jessica Rossman or her estate.
That's correct.
Okay, understood.
And let me make the point, there's no claims, and there's no interested party regarding the estate of.
Right.
I have to say, in 2018 was when Mr. Shepherd indicated he made the will. She was about to do another will with that she had retained counsel, Paul Strug, to do another will at the time she died. So whether our clients were excluded or not excluded, it doesn't make any difference. Because no one here is a party to the state, no one has a claim against the state.
So this is a pure 7-Eleven issue, nothing else.
What was that?
This is purely an issue that is to be analyzed under the temporary injunction statute, 680 and et sequitur, and 711.
The original district court judge in this case to probate court, because obviously if probate court for the Texas State's Code disregards the Texas Health and Safety Code. It would be.
Mhm.
So, you know, I think that's where we stand.
Thank you, Mr. Roth. I appreciate it. I'm sorry, did you conclude your arguments?
Oh, yes, yes, Your Honor. I mean, I don't know if you had any more questions. I was answering your questions in order.
Oh, you were doing a great job, and I appreciate your input. Do you have anything further?
Very, very briefly.
Yes, sir.
The first is the practical consideration. They say they want the actions because they want them analyzed for toxicology or whatever. Yet they rejected our offer to divide action. If they accepted that offer, they could have done whatever they wanted to do with it. And just secondly, Mr. Hicks has conceded this is based on knowledge. What he said it was based on is the definition of not personal knowledge. That is why they say firsthand knowledge. And the evolution of this is interesting, Judge, because they got that TRO, they didn't circle within the district court with a verification that says the stuff in the petition is true or correct. And that's where they, no personal knowledge, no nothing else. I filed an objection that says not only do you not say you have personal knowledge, you couldn't, because this stuff happened in Mexico and Texas, we live in Paris and New York. That's when they changed to first-hand knowledge. Well, even without Mr. Hicks' concession, first-hand knowledge got to get you there. I mean, this is extraordinary relief, and it has to be based on personal knowledge.
I agree. I find as a matter of law, I cannot grant the temporary injunction. Temporary injunction is denied.
Thank you, ma'am.
You may be excused. Thank you. Do you want your notebook back? Please don't leave them with me. I've got so many notebooks back there. I don't. But I do appreciate the demonstrative. They were very.
Thank you very much.
Thank you. All right. And that, see, I don't get